synthesizing the claims of these plaintiffs and putting them in a summary form in the petition. I really can't expand much more upon what David has already told you. The basis of our claims is that the funding mechanism for charter schools is unconstitutional. The arbitrary cap that's placed on charter schools is unconstitutional. Why? Well, because the Constitution requires suitability and efficiency, and that's been determined by some 22 years of finance litigation, the Edgewood cases, to mean certain things. And under those meanings, as determined by the courts up to this time, charter schools have not been considered. They have not been a part of the lawsuit. This is the first time, this is the inaugural time for charter schools to enter into the finance litigation. And we do so for two main reasons. One is that the courts have determined that there are two main components for facility funding, necessary components, for funding for public schools, free public schools. One of them is operations, and the other is facility. What could be a more stark example of a denial of a necessary component than zero facility funding, intentional zero facility funding for the charter schools? This is obviously an unconstitutional decision, and the other part of our lawsuit is the fact that I think it was many years ago, an arbitrary number was placed on the growth of charter schools. They were told that 215 is all you can get to. There may have been some rationale for that decision at that time. There is no rationale for it today, especially when charter schools are demonstrating the very kind of efficiency that the case law has called for all through these 22 years of litigation. And therefore, the arbitrary, artificial cap of 215 charter schools permitted in the state of Texas is equally unconstitutional. Do you have anything to add?
So with that, thanks, Bob. We'll introduce Mario Flores,
Please.
who is a parent at Wayside Schools in Eden Park.